Why are Blinkit workers protesting? How did the strikes start? What is platform work? Do the new labor codes protect the rights of gig workers? Does the Code on Social Security 2020 differentiate between employee and gig worker? Have there been petitions in courts to legally recognize gig work and workers? The name of the explainer is Aratrika Bhaumik. The story so far. The recent strike by Zomato owned Blinkit delivery agents has once again brought to the forefront issues plaguing the gig economy in the country. The strikes began when Blinkit rolled out its new payout structure for delivery executives, under which the minimum payout per delivery was slashed to 15 rupees from 25 rupees. As a result, Blinkit delivery executives are now set to earn 600 to 700 a day as opposed to 1200 before. Who is a gig worker? Gig workers refer to workers outside of the traditional employer employee relationship. There are two groups of gig workers: platform workers and non platform workers. When gig workers use online algorithm matching platforms or apps to connect with customers, they are called platform workers. Those who work outside of these platforms are non platform workers, including construction workers and non technology based temporary workers. Whether gig workers should be categorized as employees or as independent contractors has been a heated debate. In India, employees are entitled to a host of benefits under statutes such as the Minimum Wages Act 1948, Employees Provident Fund and Miscellaneous Provisions Act 1952, EPFA, and the Payment of Bonus Act 1965. Similarly, contract laborers are governed under the Contract Labor Regulation and Abolition Act 1970 and are also entitled to benefits such as provident funds. However, given the unique nature of gig work, gig workers display characteristics of both employees and independent contractors and thus do not squarely fit into any rigid categorization. As a result, gig workers have limited recognition under current employment laws and thus fall outside the ambit of statutory benefits. What is the proposed law? The Ministry of Labour and Employment introduced the Code on Social Security 2020, which brings gig workers within the ambit of labour laws for the first time. Under Section 235 of the Code, a gig worker is defined as a person who performs work or participates in a work arrangement and earns from such activities outside of a traditional employer employee relationship. The code defines platform work as a work arrangement outside of a traditional employer employee relationship in which organizations or individuals use an online platform to access other organizations or individuals to solve specific problems or provide specific services in exchange for payment. Although the code recognizes gig workers, it distinguishes between such workers and employees. While employees have benefits such as gratuity, employee compensation, insurance, provident fund, and maternity benefits, the code stipulates that central and state governments must frame suitable social security schemes for gig workers on matters relating to health and maternity benefits, provident funds, and accident benefits, among others. The code also mandates the compulsory registration of all gig workers and platform workers to avail of the benefits under these schemes. What are some of the concerns? Out of the four new labor codes proposed, gig workers finds reference only in the Code on Social Security. As a result, gig workers remain excluded from vital benefits and protections offered by other codes such as minimum wage, occupational safety, etc. They also cannot create legally recognized unions. Moreover, they remain excluded from accessing the specialized redressal mechanism under the Industrial Disputes Act 1947, denying them an effective remedy for grievances against their employers. Considering the non traditional nature of their work, gig workers also do not have the right to collective bargaining, a fundamental principle of modern labor law crucial to safeguard the rights of workers. A 2022 report by Fair Work India, an international research project, highlighted the deplorable working conditions of the employees of digital labor platforms in India and the need for statutory affirmation of the rights of gig workers. Despite receiving the assent of the President, the labor codes are still awaiting implementation 3 years on. The center has said that this is due to delay in framing of rules by the states. Have the courts intervened? On September 20th, 2021, the The Indian Federation of App-Based Transport Workers (IFAT) filed a public interest litigation on behalf of gig workers before the Supreme Court. The petition demanded that gig workers or platform workers be declared as unorganized workers so that they can come under the purview of the Unorganized Workers Social Security Act 2008, the UWSS Act, and be provided with statutory protection in the form of social security benefits. It has been contended that the exclusion of gig workers from the category of unorganized workers or wage workers under Section 2M and 2N of the UWSS Act is violating their fundamental rights under Article 14 and 21 of the Constitution. Further, it has been argued that such denial of social benefits amounts to exploitation through forced labor within the meaning of Article 23. Although the Supreme Court sought the Centre's response to this petition back in December 2021, the Centre has yet not responded.